Did it come up right? Yes.
Yes.
Yeah. So I think what I'll do is I'll talk through sort of just whistle-stop tour of the guiding principles and use some scenarios just to explain the principles. But then I would really like to hear from the parents about your experience, because every situation is unique, and we need to at every point review what's in the best interest of that young person, your child. So I think, as I said, the first bit is knowledge is power, and arming yourself with the information. So, and then also different organizations have different policies, and they are usually, there are links on their website so that you can look through that specific organization's policy around information sharing. So that's freely available, but that's a real task to arm yourself with that at the same time, engaging with professionals that you've never met, sharing information which is sometimes really difficult and traumatic to share, but all of that's important to help us to get the best outcomes for our young people who are admitted to hospital. So the three pieces of legislation that constantly interact and that we need to weigh up is the Children's Act, because a child is, in the eyes of the law, is a child until they're 18. So that's the Children's Act. The second legislation that's important is the Mental Health Act, which has no upper or lower age limit. And then we have the Capacity Act, which kicks in when a young person turns 16. And often it's these three pieces of information, of legislation, that we need to use and ultimately use in a way that gets the best outcome for that young person. So if we talk about capacity, so capacity strictly applies to those young people who are 16 and 17. And that's the Mental Capacity Act that was brought in 2006. And that gives us guiding principles of how do we assess that young person's capacity to consent. Now, whether that is to consent to admission, whether that is to consent to treatment, it's decision and time specific. So we might find ourselves in a position where a young person might not have capacity, and then the onus is on professionals to help and support that young person and enhance their ability to have capacity. So if we have a young person and it's about a decision about treatment, the onus is on us to give information to that young person that is accessible. So when we have a young person perhaps with a learning disability or who has autism spectrum disorder, we need to ensure that we do everything we can to help that young person to make an informed decision about whether that's admission or whether that's about treatment. So that onus is on us. The other guiding principles is that capacity should be assumed, but it's more tricky when it comes to mental health. So I guess the most common example that we get is a young person who's 16-year-old, and this is before admission, and they might be in the community, and they might have taken an overdose of paracetamol, for example, and they go to hospital, and they may have consented, and they might have had capacity to consent to having their bloods done. And then we find ourselves in a position where they've had their bloods and they need treatment, and then they decline treatment. What do we do? And that's where the Mental Capacity Act comes in really handy, where the doctors or the nurses who are assessing that young person's capacity can then use the test. And there are four bits that we need to assess. So the first bit is, does this young person understand the implications of having treatment or not having treatment? Second bit is, are they able to retain the information that you provide them around having treatment or not having treatment? Are they able to communicate their decision? Are they able to say yes or no? And then are they able, and this is the bit that sometimes our A&E colleagues miss, is are they able to weigh in the balance the risks and the benefits of that intervention? So if it's paracetamol overdose, for example, then the treatment for that is Parvalex, which is an antidote for paracetamol, and it protects the liver. And we have a short time frame to give that medication, otherwise our young person will end up with liver failure. And if it is somebody who is very distressed at the time and they've taken an overdose because they feel suicidal at the time, they might be able to understand, they might be able to communicate, they might be able to retain, but their ability to weigh in the balance the risks and benefits of that information, that treatment, is impaired because of their suicidal feelings. And that would be the test where we would say, okay, so they actually lack capacity to consent, and we can then give them the treatment against their wishes. What we have to bear in mind is if it's any young person under the age of 18, we have to involve parents in that decision as well, and that's the Children's Act. So you can see there's a potential conflict between the Mental Capacity Act and the Children's Act, where we have to involve parents. And I think that's just an example of where we would apply capacity to consent. If we take it back to inpatient admission, so on our general adolescent units, a lot of our young people will be admitted as an informal patient. And again, their capacity to consent to that admission will have to pass the 4-stage test. Are they able to understand, retain, communicate, and weigh in the balance the risks and benefits of being admitted versus not being admitted? And that's quite a big ask, especially if a young person is admitted for the first time. They might not know the risks associated with being admitted to a general adolescent unit, because none of these admissions come without risk. There's a risk of contagion, there's a risk to family disruption, education disruption, there's social circle disruption. So it's quite a big ask, and that needs to be revisited regularly. And I guess we as professionals also need to bear in mind, if a young person is getting worse, if hospital admission is making things worse, then we also need to be brave enough to say, we actually think we now need to discharge. But that initial assessment on whether a young person has the capacity to consent to admission has to be, those 4 stages needs to be fulfilled to ensure that we have informed consent for that admission. It's a bit more tricky for our under 16s because capacity doesn't strictly apply. However, a young person of age 13, 14, or 15 who has the mental maturity can consent to treatment without their parents being involved. And that is Gillick competency. And it applies the same principles. Are they able to understand, retain, communicate, and weigh in the balance the risks and benefits of that treatment? A young person under the age of 16 cannot refuse treatment. And this is where the onus is on the parents. And we call that parental zones of consent. So a parent can consent to that young person being admitted, to that young person receiving treatment for overdose if the young person is not consenting. And again, that's a big responsibility on parents. And I guess we also need to recognize that some of our interventions might be outside of the scope of parental consent, especially if that intervention carries risk. And at that point, is a safeguard for medical practitioners and nurses to then go to the court of protection to authorize that treatment. Because sometimes it will be, the intervention might carry such a big risk that it's not fair to just base that intervention on parental zones of consent. So there's an additional protection for parents, and we can then go to the courts and get a judge to authorize that treatment if the patient is refusing. So I've covered quite a lot of ground there, but I just wanted to share an example or examples of how we would use capacity and competence to consent to treatment, or capacity and competence to consent to inpatient admissions. So does anybody have any questions from what I've said so far?
See how complicated it is.
Absolutely. And I think sometimes when things are really tricky and we struggle, we have the opportunity to then discuss with the trust solicitors just to get additional legal advice. Sorry, John. Hi, John.
Hi. Yeah, I was just interested in the ages there. So, my daughter has had a capacity assessment. She's at 14 and at 15, about whether she can make up her mind to have us visit as parents. Um, and it's it's felt a strange decision that's been made around that. And so just interested in the ages. And so you say it does get used for under 16s.
It's not capacity, then it will be a competence assessment.
I mean, it was definitely called a capacity assessment.
All right.
I mean, I've got that written down
Okay.
and everything, but yeah.
So I think, John, it would be really useful if you look at the resources that I've shared. Excuse me, they are all links which you can go in. So the Mental Capacity Act strictly applies to those young people who are 16 and 17. The Mental Capacity Act does not apply to under 16s. Sometimes the word competence and capacity is used interchangeably, but strictly within the eyes of the law, it wouldn't be a capacity assessment, it would be a competence assessment, John.
Okay. Well, that's different to what I've had, but it's good to know. Thank you.
Okay. So that is the Mental Capacity Act 2006, the Mental Health Act, which I said has no upper or lower limit. Now, when a young person is admitted to an inpatient unit, and for instance, they're on a Section 3 of the Mental Health Act, which is a treatment order. In the first instance, it can last up to 6 months. When it's renewed, it's another 6 months, and then it's up to a year. So that's for our young people who have been in hospital for quite some time. If that young person takes an overdose whilst on leave, or they stop eating and drinking, we have another legal framework that we can use to treat the physical complications of their mental disorder. So I don't want to confuse things, but I think it's important that you, as parents, are aware of this. So say, for instance, it's a 14 or 15-year-old who stopped eating and drinking in hospital. They're on a Section 3. Then, as the responsible clinician, I can authorize the treatment, medical treatment, as the complications of their mental disorder. So if that mental disorder, so if they have, for instance, anorexia nervosa, I can use the Mental Health Act to authorize the medical team in the acute hospital to treat that young person if they are not consenting. And that is called Section 63 of the Mental Health Act. Okay, if it is a 16 or 17-year-old, I would typically write in my letter to the hospital, they can use Section 63 or they can use the Mental Capacity Act, because the Mental Capacity Act also comes into play when they're 16 or 17. If that young person is refusing treatment and they might need intravenous fluid replacement, or they might need NG tube feeding if they're refusing to eat and drink. So that is treating them in medical emergencies, treating the physical complication of a mental disorder. So that's another framework, but that's for somebody who's already in hospital. But if somebody's in the community and they go to A&E and need treatment and they're refusing, then it would be strictly the Mental Capacity Act or parental zones of consent. If the young person is under 16 and I authorize Section 63, I can't use the Mental Capacity Act. However, I would normally put in the letter as well, you can contact this young person's parent on this number to gain parental zones of consent as well. And it all depends on the degree of the intervention and the risk that it carries, because I think it's really important to not put the parent in a position where they are authorizing or agreeing to treatment that carries a risk. And that's why, there needs to be a protection for parents as well when we do these, make these decisions. And I guess the same applies to information sharing and confidentiality. This is a bit more tricky because we want our young people to feel that they have a safe place to talk about their difficulties, perhaps about difficult experiences in the past. However, on admission, and then it's repeatedly reviewed during the admission. On admission, we do talk to our young people about the bounds of confidentiality. And here we are strictly bound as doctors by the GMC code of conduct around confidentiality. So all young people are have the right to confidentiality, but there are bounds to that. And when we decide, and it's a big decision, to break their confidentiality, we need to follow the GMC guidance on this. And this is usually around risk. So this could be around risk to self or risk to others. So if that young person shares anything with us that makes us wary that they are either at imminent risk to themselves or somebody else is at risk, we are bound to share that. The rules around that is that we need to tell the young person what information we are sharing, who we are sharing it with, and our rationale for sharing it. So just to give you an example, if a young person asks us not to share information about the incidents that they're having on a ward, however, you as a parent come the following day and taking them out on leave, I think at that point we do need to seriously consider sharing that information with you. It would be very unwise for us not to share that information with you. And I think how we would typically work is we would share that with the young person. We are duty bound to share risk information with your parent. You are going out on leave with them. This is the information that we will be sharing with them. But we would like to give you the opportunity to share this with your parent first. But if you don't share it, we will be sharing it. So I think then we give the young person that opportunity to talk to their parents about what's happened so that they can explain that to them. But we cannot send a young person on leave if they, for instance, tied multiple ligatures the night before without sharing that with that parent. Because if something happens whilst they're on leave and we've not shared that information, we're putting her or him at more risk, or even you at risk, if we don't share that information. But I've shared all these resources around that with Becky and Anita and Kat so that they can share that with you. I'm going to pause there and just ask if you've got any questions, because again, there's nuances to every single situation, and it is complex. But does anybody have any questions around information sharing?
Has anyone got any examples or scenarios, or is there something that you have experienced in your kind of own journey that you wanted to just double check or check out, Farida?
Yeah, my mic's off. Can you hear me? Yeah.
Yeah.
Okay.
Yeah.
I mean, for me, we're talking young people who have then got some sort of mental health illness, which double makes them complicated. To add to that, they've got autism, they've got ADHD, and they're diabetic, and they've got a whole host of other stuff. It's difficult when you're seeking consent of autistic young people, and the way that consent is thought doesn't make sense to the young people. I still don't think the communication's quite right with what is consent. So I'll give you an example. Young person consents, yeah, you can share. And then he has 20 other people asking, do you have consent to share? There must be some generic way that once the young person's given consent to share within the realms of who those professionals are, there can be a shared consent form. So our example is, our young person's got all those problems and he's got 30 people asking, can you sign a consent form? Can you sign a and at that point, it's just like, you can go and stuff your consent forms, yeah? And I don't blame him, because I'm peed off with the number of consent forms and I'm not even there. So there's just something about, really, all these acts are great and they are to protect the young people, but actually some of them are hindering what is a young child's ability to get the access to services that they can't comprehend, and that actually somebody in their family can. So I'm sorry, I'm sounding frustrated, because it's a whirlwind for me And I cannot imagine, you know, a young person, 16 years of age, can you sign this? Can you sign that? Can you do this? Can you get that? I'm like, what the? Sorry.
No, absolutely, Dr. Frida. I think that's a common experience. So every organization works differently, but typically that question about sharing information is asked on admission. And the proviso is if the patient consents to sharing information with parents, with professionals, that consent can be withdrawn at any point. However, we would like to revisit this. So typically that's revisited in ward rounds. Some organizations have a checklist. Every ward round we check, are you still happy for information to be shared? And I think it's important to empower young people that they are aware of what is shared and with whom it's shared. But if they've consented on admission, I think it's important for us to check periodically, are they still of that mind? If they're not consenting, again, that might be that at the time of admission, they weren't able to understand. So the capacity assessment needs to be done then. So if they're not consenting and they lack capacity, then that discussion will be had with the parents as well and say, at the moment, they lack capacity. So say, for instance, a young person is admitted with acute psychosis. They're unable to understand what we're talking about. They're unable to retain. They're unable to weigh in the balance. They're able maybe to communicate and say, no, don't share, because they might be paranoid or suspicious at the time. However, but then again, the onus is on us to revisit that with them, to empower them again during their journey of recovery. So I think it is very nuanced. But I think if we are not sharing information, we need to have, for parents, we need to have a very good reason that's defendable, and especially when we're talking about risk, to not share information. I think the other bit about that is that doesn't stop parents from sharing information with us. So whilst we might not, if a person is capacitous and not consenting for that information, that doesn't stop us from getting information from you, because we might be experts in mental health, but you as parents are the expert in your child. And we cannot work in silos. We have to work with you to get the best outcome for that young person. So whilst the young person might not want us to share information with you, if they're capacitous, we can still get information from you. And I think that's important as we work with young people and the families through the recovery journey. But I think, again, if you come across these obstacles, I think it's so important that you speak to Becky. The advocates for you would be the family ambassadors, and then arm yourself with information. Otherwise, it will impact on the young person's journey with us, and we need to check things out with you. So I just wanted to also talk about Caldecott principles of information sharing. Now, that is for professionals to share information with each other. And then Caldecott came up with 7 principles. But she's reviewed that and added an 8th principle, because people were using this not to share information with each other. And that was against the spirit of the Caldecott guidelines. And then Caldecott then said, it's as important to ensure that we share information and be bound by that professional sharing of information as it is to sometimes not share information. But I think people were using the Caldecott principles to not share information, which is ludicrous. We cannot work in silos. Otherwise, that young person is never going to get the care and treatment that they need. And, they might get stuck in hospital, which is, not what we want. So I don't know, Farida, whether that
Farida, I just wanted to clarify something. I might have misunderstood. Is this around the journey into inpatients? Was the request around, or a repeated request around consent from the different teams or organisations that your young person kind of went through and experienced, or was this just on the inpatient unit?
No, I don't think it's on the inpatient unit, but they don't just come on an inpatient unit, do they? They, you know, if they're part of CAMS or if they're part of something else, or if they're part of if they're part of another project, there just seems to be, my experience is a resistance to truly integrate communication because everybody hides behind confidentiality and then put the onus on the young person to go, oh, okay. And yet, if they understand all of those services are going to be so relevant to their discharge that actually withholding information's got a massive impact. But I mean, I can only speak for us, but it just sometimes feels that the two systems are not integrated. So you're either out or you're in, and you're in and you belong to the in, and you're out and you belong to the out. And you kind of spend your life going, oh, sorry, where's the golden thread? You know, where's the links between these services that say I'm here for you when you come home, I'm there for you when you're in. It's just like when you're in, nobody's from the out, and when you're out, no one's from the in. And I'm like, wow.
Yeah.
So fragmented. It's no wonder people are falling through the net.
So that sounds like the Caldecott principles would apply. Sorry to speak technical, but I think that, you know, we cannot work like that. Because young people will then get stuck, or important information around risk is then not shared with the community team, so people will get it wrong. So I think, you know, again, information is power, Dr. Farida. Honestly, I think if it's power
for us, I think definitely information is power, but how we receive that information, Doctor, is really important for us. And we receive it often in a way that you all understand, but I don't understand. You know, I kind of feel like I've took a degree in mental health and psychiatry, and I'm playing at this. If it's not on Google, then I don't know. You know, it's just like, it's so difficult because your language is your language.
Absolutely.
Our language is our language. And if you come from a diverse background, to be honest with you, you just feel like you've landed in Mars.
I'm wondering whether I'll ask. So on our service, we've developed a jargon buster for parents. So when young people are admitted, we send this because it is so jargonistic. CPA, PRN, all of these.
EPHCP. Oh my God.
Exactly. So I wonder whether I think we'd be more than happy to share jargon buster. I don't know, Kathy, if that would be helpful. More than happy to share for parents, because it is negotiating a whole new world. For a young person to be admitted to hospital. I think the other bit which you touched on there, again, around young people with neurodiversity.
Absolutely.
We have more responsibility in terms of our communication with young people with neurodiversity. Being neurodiverse is a superpower. I firmly believe that. And I think that's a really important shift for the young person who often feels that they've just been labeled with something else. However, the onus in terms of communicating with our young people with neurodiversity, it's us, we as a system need to adapt our communication to ensure we empower that young person to make an informed decision. And I think what you touched on there about weighing up in the balance the risks and benefits of not sharing this information with the community team might actually hinder the discharge. So I think that should be the kind of discussion. If a young person is not consenting for that information to share, I think there needs to be very clear assessments around what is getting in the way. So if I get more worried if a young person says, no, don't share, because I want to understand what is that about. Is there a safeguarding concern? Or is this actually part of their mental health difficulties? They need to control what happens. Could it be that they are suspicious about where the information is going? So I need to understand, I think there's a higher level of understanding that's required if a young person is not consenting. We want to obviously keep things confidential. They have a right to confidentiality. But when it comes to risk management, when it comes to sharing information around management in the community when they're in a hospital, I think it's a higher bar of needing to assess what is it that's getting in the way for that young person. Why is that young person not wanting to consent? for this information to be shared, because that's potentially very risky. And how can we defend that if we are not sharing vital information? And then the other bit would be to talk to them about the bounds of confidentiality, because we are also duty bound to share information if there is a potential risk to themselves or to others.
Oh, thank you. Thank you.
John?
Hi, yeah. Excuse me, sorry. I requested some some information about my daughter's care from early on, before we really knew what was happening, and we weren't invited to MDT meetings and stuff. And my daughter declined and said she didn't want us to see them, and so that was where the journey ended, and so never got to see them. Is there anything I could have done, or anything I can do?
That's tricky, John. I think challenging that decision and asking how that decision was concluded would be one way, because not involving you, there could be reasons that your youngster has told the MDT. But as a parent, I would be very keen to understand how did they get to that conclusion, so that I can understand. Otherwise, it feels very fragmented, as Dr. Farida said. It feels very, split. And if we're working towards discharging, because that's ultimately the goal, is we, as an inpatient team, we only have a very short but potentially important role in your young person's recovery journey. But we are talking about discharge from the moment that they're admitted. So if that young person is not sharing information, we need to understand what that's about. And you could request that that's revisited, because that feels really tricky. And as a parent, that will just increase your worries. That feels really tricky, John.
Okay, thank you.
Okay, any other? Oh, hi, Helena. Helena, I hope I could pronounce that correctly.
Hello. So I wanted to seek your opinion about something which is bug of mine. So my young person, after almost 2 years spending in bed, was admitted to the hospital, and he was at the time still 15. And my big hope was they will do laboratory tests to rule out anything physical.
Yeah.
For any physical reason for his behavior, him being bed bound practically. He refused tests, so he spent almost 3 years in bed. Still not much change, but had no legal way to get him those tests done. Even I was saying, my opinion is he should have it done even against his will. Was there anything I could have done at the time? Because they decided it's not in his best interest, it will be traumatic. Was there anything I could have done at the time to challenge it?
That again sounds very complex, Helena. When he was 15, you could have consented on his behalf if the clinical decision was to have these bloods done. I think it's a difference if parents are asking for it. If the clinical team feels that there's certain investigations that can be done, they can do a competence assessment. Under 16, a parent can overrule the patient that's not consenting. It sounds like you mentioned best interest. So once they turn 16, the Capacity Act kicks in, and then there would be normally a best interest meeting where they will discuss the pros and the cons of that intervention versus not. It sounds like they fell on the side of it will be traumatic to do this in holds, which none of us want. But if there was a clinical indication for those bloods, the doctors could have then used the Mental Capacity Act to obtain those blood investigations if he was not consenting. So there would be those legal frameworks. But I think it's more tricky if a parent is asking for these bloods to be done and the clinical team doesn't agree with that. need for those blood investigations. I don't know whether that makes sense.
I mean, in my opinion, there were grounds to force those tests. I'm still not in the knowing what's going on really, because he's now in the community and there's even less powers to do anything like this. I just felt like I have no choice at the time. There wasn't anywhere I could turn and learn how to challenge it if there was a way.
Yeah, I think that's very tricky. But so if the clinical team felt that those blood needs to be done, they could have asked your permission before he was 16 to do that against his wishes, or if he's over 16, have a best interest meeting. And if a young person has a parent, the parent's wishes are pertinent. If a young person is brought up in care or parents aren't able to make those decisions, then an IMCA, an Independent Mental Capacity Act advocate, is appointed. But usually when there are parents involved, it will just be a discussion with the parents, Helena.
Yeah, so they didn't take my opinion seriously in that case, I feel. So now, because he's in community, but he's actually in the step-down placement, does it mean he can have advocate now?
He should have
that decision to be made.
Yeah. So so it depends on how old he is. How old?
He's 16 now.
16. So the Mental Capacity Act would be the way to do this, especially in the community. That's what we would typically do. If you are involved in his day-to-day life, and if you are the person who holds parental responsibility, then you would be the person to be consulted for the best interest meeting around that. But it sounds like you are having some difficulty convincing the clinicians that he needs blood.
So at the moment, there isn't clinician as such in the placement. There's a psychologist and there is community pediatrician. And he did have capacity assessment done, but it was in relation to where he's staying and I think wider treatment as well, but it doesn't mention the bloods. So I don't know if it's something I could use as well.
Yeah, because I think the difficulty there is those capacity assessments to consent to assess investigations, those things, it has to be clinician driven. You as a parent can obviously raise the concerns with the pediatrician who's involved and say, look, he has never had these blood results. Don't you think it's a good idea to get them? I will consent if he is not consenting, and that can then go to a best interest meeting. But those decisions around investigations, assessments, those things should primarily be driven by the clinician. You can certainly ask those questions, and please do to the pediatrician, see, for a full workup around his symptoms, don't we need to do these bloods? And then they can make a decision about that. But it sounds like that's where the difficulty is.
Okay, thank you.
Thank you. I don't know if there are any other questions for Laurie. I even though I live and breathe it, it's definitely interesting and a good refresher. And you can see how complex it is to try and weave it all through and make sure the young people feel they are validated and listened to, and you can build therapeutic relationships with them, but then also managing the risk and the legal aspects. It definitely is really, really complicated. Hopefully that's been really, really helpful to the parents, and it's been really interesting having some of the scenarios to bring it to life a little bit.
Just to, if there are any other questions, Kat, I'm happy to have them, because sometimes after a talk people think, well, what about this or that? Obviously, I don't have any clinical responsibility for a young person, but I might be able to point you in the right direction. So if at the end of the resources, if there's any questions, I would be more than happy to support and maybe redirect if I can. But thank you so much for the opportunity to talk to everyone. It's
thank you, Laurie. It's really
Laurie.
good.
Appreciate
Of
you.
Thank you.
Yeah, really, really helpful.
Thank you.
Fabulous.
Thank you very much.
I hope you have a nice rest of your evening, Laurie. Thank you again.
Take care. Bye-bye.
Bye.
Take care.
Thanks.
I will. I'll remember to stop recording.